Hello, everyone, and welcome to our webinar, giving you a first look at the UK's proposed online safety bill. I'm Adam Rendell, a partner in our IP Media group, and I'm joined by colleagues Mark, Tim, Zuyang, and Louise. We all advise services which host user-generated content, and it's those services which are the focus of this webinar. A couple of points of housekeeping before we start. We're on video, but you're not, so you're not visible to each other or in the recording. If you've got any questions or comments, please ask them in the Q&A box in the bottom left corner, and we'll do our best to pick them up as we go along, or otherwise follow up with you afterwards. And at the end, you'll see a feedback survey, including a place for you to suggest topics for future sessions. So please do give us some suggestions about what parts of the proposal you'd like to hear more from us on. On the agenda, I'm going to start with an overview of the legislation and an attempt to visualize its various elements, and then we're going to do a deeper dive into some of its more complex parts. Now, some of you may be thinking that you've been hearing about online harms and online safety legislation in the UK for a while now. So why are we still only talking about a draft piece of legislation? And you're right. I mean, it's been over 2 years since the initial white paper was published by the government. That was followed by a public consultation. And then last year, initial and final responses came out of the government. At the same time, the Law Commission has been formulating proposals to better protect victims from harmful online behaviour. And most significantly, just before Christmas last year, the European Commission announced its long-awaited Digital Services Act, which in its words sought to foster responsible and diligent behaviour by providers of intermediary services to ensure a safe online environment. And in a clear example of regulatory divergence post-Brexit, the proposals, while they've got similar aims, are structured and will apply very differently, but services between the UK and the EU will have to comply with them both. The legislative process for the Digital Services Act is underway. It's currently before the EU Council, then the EU Parliament is going to take over later this year. And finally, on the timeline, this bill is about to undergo pre-legislative scrutiny, so it's unlikely to be in the same form by the time it starts its formal legislative process as it is now, but that doesn't mean we can hold off preparing. The measures this bill imposes will be so fundamental and so wide-ranging that the practical preparations and the public affairs engagement should start now. Now, there's one piece of legislation I haven't mentioned on here, and that's the AVMS Directive's video sharing platform regime. That came into force in the UK at the end of last year. But for those of you who work for services that are subject to that UK regime and subject to Ofcom's oversight, the regime is going to be repealed as part of this legislation. Now, you don't need us to tell you what a harmful, unpleasant environment the internet can be, nor that dealing with that harmful environment has been a priority for governments around the world for a while now. So what does the UK government want to do about it? Well, it's not taking action against the primary wrongdoers or the publishers of that unpleasant, harmful material. And it's not seeking extra powers for the state to be able to remove or censor material. And it's also not reforming the law around, at this stage, what is and isn't unlawful. What it's doing instead is essentially to outsource the policing of this harmful content and the taking of some very difficult content moderation decisions to the services through which that content is shared. And that's services of all shapes and sizes. It's doing that primarily by imposing various and extensive duties on services. At its core is a duty of care to ensure user safety, and that's buttressed by various supporting duties like the need to conduct risk assessments, and is balanced to some extent with competing demands of freedom of expression. And it's subject to significant regulatory controls from Ofcom, who will have far-reaching powers and ability to impose fines of up to £18 million or 10% of global turnover for non-compliance. What this legislation also doesn't do is amend the concepts with which we're familiar from the e-commerce directive, the hosting immunity, for example, is preserved. However, there could be considerable risks in practice that complying with these online safety duties can reduce services' ability to rely on that immunity. Now, the current intermediary liability regime in the UK and across Europe encourages services not to moderate, not to take proactive measures to keep their platforms safe, and it also sort of incentivizes services in the event of a complaints about unlawful content, just unlawful, sort of illegal content, to take that content down as soon as they can. But both of those elements of the current regime are now less available. Services will be required proactively to assess the risks their platforms pose for user safety, then do various things about them. And instead of just sort of taking things down without much fear for the consequences of doing so, they'll also have to take into account freedom of speech. But it's worth noting that the new regime doesn't make intermediaries liable for the unlawful or the harmful content itself. So let's jump into the detail of the legislation. It's so complex and multi-layered that I found it much easier to try and visualize its various elements into a diagram. The first bit of the diagram is on screen now. The departure point is that these duties apply to user services and to search services. We're primarily going to speak about the user-to-user services, just in interest of time, but there are substantial overlaps between the user service and the search service regime. And I'm going to hand over to Louise, who's going to explain in more detail what those services are and what's excluded. Louise.
Thank you, Adam. So who, as Adam says, who and what is in scope? So it's not completely straightforward, but largely the duties imposed by the legislation apply to regulated content provided by regulated services. I say it's not completely straightforward because the legislation isn't drafted quite that simply. It takes a more layered approach to the duties. And importantly, not all of the key terms have been defined yet, but for the most part, we're talking about duties in relation to regulated content provided by regulated services, with some possible exceptions. So let's look at those definitions and then we'll try to flesh it out with some examples. So a regulated service is a user-to-user service or a search service that is not exempt and has links with the UK. So as Adam said, we're going to focus largely on user-to-user services today. User-to-user services are internet services whereby content that is generated, uploaded, or shared by a user may be encountered by another user. So effectively, it's services that enable at least one user to experience content generated by another user. And whilst this might seem relatively straightforward, the more one digs into the legislation, the more one realises that there are a number of uncertainties and that the definitions could potentially have quite a broad application. So just digging into that a bit deeper, the definition applies to content generated, uploaded or shared by a user. However, it's not clear who is a user. We know who aren't users, that's spelled out in the legislation. So officers and employees of the provider are not users. And likewise, those who provide a business service to the provider, such as a contractor or a consultant, are not users. I think that's going to be quite an important provision to look over and working out whether a particular content might not be caught because it's generated by a person who provides business services to you. And that content is supplied in the context of those services. So we wait to see how broadly or narrowly that provision is interpreted. But everyone else seems to be a user, so that's potentially quite broad. So I think the key point is we're not just talking about content generated by end user consumers here. We also need to be thinking about any content that you have which is generated by a third-party business or professional with whom you work. That might also be caught. Another key point is that it's not only content that is directly uploaded or shared by the user that's covered. Content generated by a user appears to be covered even if it's not directly uploaded or shared by that user. And if that's right, then yet again, that potentially widens the scope of what is covered. So picking through these issues and understanding what content is shared on your service, where that content comes from, how it's uploaded, by whom, what your relationship is with that person, are all going to be important factors in determining whether you're caught and what your duties are. A few other points I wanted to mention on user-to-user services are, firstly, the definition of what constitutes content is very broad, and therefore what constitutes user-generated content is also very broad. So content includes anything that can be communicated via the internet. So that could be written materials, visuals, oral materials, any form of data. So in terms of user-generated content, that could include a wide range of things, including setting up a user profile, sharing location information, clicking on an emoji, expressing a view on content, or even turning on your webcam. All of that is potentially caught if done by a user. The requirement is that the user-generated content may be encountered by another user, so it doesn't have to be encountered in fact, just that it's possible for it to be encountered. Encountered is drafted very broadly and includes reading, viewing, hearing, or otherwise experiencing the content. And as long as at least one other user may encounter the content, that's sufficient. It doesn't have to be encountered more widely than that. So something like direct messaging would be caught. But importantly, the content has to be encountered on the same service to which it's uploaded. So if a user encounters the content elsewhere on another service, that wouldn't be caught. Lastly, it doesn't matter what proportion of your business falls within the definition of a user-to-user service. There's no de minimis requirement here. So careful consideration is needed as to all the services you provide, including those you might provide at a relatively low level, those you might only provide periodically, and potentially also you might want to look forward to see what services you might provide in future to see if they're caught. The other category of service covered are search services. These are internet services that are or include a search engine. A couple of points to note on that. Firstly, again, the definition of what a search engine is quite broad. It includes any service that allows the user to search more than one website or database. So we're not just talking about large search engines here, it's much broader in scope than that. And secondly, although it's not, doesn't come out in the definitions, the duties in relation to search services only apply to user-generated content that is encountered in or via the search results or listings. So again, we're not talking about other forms of content here, it's UGC. Certain services are exempt. Some of the exemptions apply only to user services, and some apply across both types of service. So where the only UGC enabled by the service is emails, SMS messages, or MMS messages, the service is exempt. Limited functionality services are also exempt, so this is any service where the only UGC present consists of user comments and reviews on content that is published by the service itself. So this effectively means that below the line user comments and reviews on your content are going to be out of scope. And I think that's going to be an important exemption for many people. If the only UGC is one-to-one live oral communications, then you're exempt. If the user-to-user service or search service is provided by a public body in the exercise of its public functions, it's exempt. And lastly, internal business services are also exempt. So things like internal message boards or internal search engines for use by employees and officers are not caught. It's worth just adding that these exemptions are quite tightly drafted and so would need to be properly reviewed on a case-by-case basis to see if they apply. The third criteria is that to be caught, the service must have a link with the UK. This means that the service either has a significant number of UK users, or UK users form one or the only target market for the service. That seems relatively straightforward. There's also a third category where a service will also be deemed to have links with the UK if it's capable of being used in the UK and there are reasonable grounds to believe there is a material risk of significant harm to individuals in the UK from that content. So this is a fairly wide catch-all covering high-risk services accessible in the UK. So the legislation does have this quite significant extraterritorial application. I'm not going to spend too much time looking at what constitutes regulated content. It's user-generated content with certain exceptions. And the user-generated content is defined almost identically to the way it is defined in the context of user-to-user services, with the additional element that content generated by means of an automated tool is also covered. Again, certain types of content are accepted, so these exceptions overlap somewhat with the exemptions I've just talked about for regulated services. So content is not within scope if it consists of emails, SMS messages, MMS messages, comments and reviews on provider content, one-to-one live oral communications. And in addition, content is not in scope if it consists of paid-for advertisements, which are defined, or news publisher content from recognised news publishers. And again, these exceptions need careful consideration because they are drafted quite tightly. So trying to bring all of that together, I think it goes without saying that there's some online service providers who are quite clearly going to be within scope: social media companies, content sharing platforms, marketplaces, blogs and forums. Online gaming will also be caught. In fact, the legislation makes clear that playing a game online where others can observe you playing that game or play alongside you is user-generated content. But really, there are also going to be a whole host of other services that are potentially caught because they display third-party content, perhaps content contributed by other businesses, or because they have particular functionalities on their site. So a careful scrutiny of the services and content that's provided is going to be necessary to understand the full scope of your duties under this legislation. So I'll now hand you back to Adam to continue his overview of the legislation.
Thanks, Louise. So carrying on my sort of attempt to visualize the legislation, the legislation adopts a multi-tier approach to the imposition of duties. There are a general suite of duties that apply to every regulated service. They're the 7 that are on screen now. And then there are additional duties for services likely to be accessed by children, and a further set of duties that apply to what are described as Category 1 and Category 2 services, which we'll come on to in a couple of minutes. I'm going to start now by considering the duties that apply to all services. All services have to carry out illegal content risk assessments. They're a fundamental building block for the rest of the legislation, and Mark will consider them in more detail shortly. That risk assessment is an assessment to identify, assess, and understand a range of factors as appear to be appropriate, which take into account the risk profile of the service. All services have to assess their accessibility by children to determine whether it's possible for children to access the service, and if it is possible, whether a significant number of children are users of the service, or if the service is of a kind likely to attract a significant number of users who are children. Providers must keep the written records of those assessments. And if it is possible for children to access the service in these ways, the service will be treated as likely to be accessed by children, and with that comes the extra duties I'll mention shortly. There's then the core illegal content safety duty, which is the duty to take proportionate steps to mitigate and effectively manage the risks of harm to individuals. Those risks, as identified, this is important, in the most recent illegal content risk assessment. Duty then to minimise presence of content and take down content when on notice. All services have got duties about freedom of expression and user privacy. That plays in as a duty to have regard to the importance of protecting freedom of expression and protecting unwanted infringements of privacy. That applies when deciding on and implementing safety policies and procedures. All services need reporting functions and redress processes. So that's a duty for you to allow users and affected persons to report content they consider to be illegal, and then to operate a complaints procedure. Complaints about the presence of illegal content, sort of normal. Complaints about the provider not complying with its duties, its safety and freedom of expression duties. That's sort of a bit more ambitious. But then finally, and very sort of novel, an ability for users to complain where those users are the ones who have shared the content that's been taken down. And then there's duty to provide for appropriate action to be taken in response. And the policies and procedures that govern the handling of these complaints have to be publicly available and accessible. Services have to keep records of every risk assessment they take, what steps they take to comply with their safety duties and their reporting and redress duties. And they've got a duty to review compliance with them. Certain services that hit qualifying worldwide revenue thresholds have to notify Ofcom, and certain services, again, calculated by reference to qualifying worldwide revenue, will have to pay a fee. That fee will be determined by reference to the revenue and other factors Ofcom considers appropriate. Ofcom has got to publish a statement of principles governing its fees. All we know is that those fees are going to be, or the amounts of the fees will be calculated by reference to how much it's going to cost Ofcom to meet or to exercise these functions. The impact assessment refers to costs of an estimated £46 million that need to be shared. So that's all services. Let's just mention briefly services that are likely to be accessed by children. They have to carry out a specific children's risk assessment about the level of risk of children encountering various types of content classified as being harmful to them, to protect children's safety. Again, those risks of protect against the risks of harm identified in the risk assessment. And then the reporting and redress duties I mentioned earlier also apply to the content that's considered harmful to children. We then move on to the category services, or category 2 first. I'll bring up category 1 as well. So Ofcom will decide which services go into category 1 or into category 2. Not all services will be either category 1 or 2. It'll be identified by Ofcom using threshold conditions, which will be based on things like number of users, the risk of harm, and functionalities to be set out in future regulations. Ofcom will maintain a register and will allocate services to the various categories. The idea here is that for the higher risk services, they'll have more onerous duties. Now, the category 2 services, their kind of additional onerous duty is the obligation to produce an annual transparency report. That's got to be submitted to Ofcom and published, and it's got to contain information that Ofcom requires, which can cover up to 13 different topics about the incidence of illegal and harmful content, how many users encountered that content, how it was disseminated, information about how the terms of service have been applied, and how the systems and processes have worked. That annual transparency report is also an obligation for category 1. But as you can see, they've got a whole heap of other additional obligations. We mentioned before risk assessments being the kind of bedrock foundation of the legislation. Category 1 services have to do a risk assessment in relation to the risk of adults encountering types of content which is classified as being harmful to them. And one of the things that's probably captured the imagination, the horror of people, is the duty to protect adults' online safety, even when the content is lawful. And that comes in via an obligation in the duties, an obligation in terms of service, how certain kind of harmful content will be dealt with by the service, and a duty to ensure the terms of service are clear, accessible, and applied consistently. These Category 1 services have got a group of 3 obligations around freedom of expression. The first on when deciding safety policies and procedures, to carry out and publish an assessment of the impact those policies and procedures will have on freedom of expression and privacy, and to publicise positive steps taken in response to that impact assessment so they can protect freedom of expression and protect against unwarranted infringements of privacy. Secondly, these Category 1 services have got a duty to protect content of democratic importance. That comes in by those services when they use their systems and processes to ensure the importance of content of democratic importance is taken into account when making decisions about treatment of content and how to treat users. And thirdly, a duty to protect journalistic content, which is to ensure that the importance of free expression of journalistic content is taken into account, again, when making decisions about how to treat and whether to take down content and how to treat users. And finally, the reporting and redress obligations I mentioned that apply to all services, they also apply in relation to the content that is considered harmful to adults and the Category 1 services non-compliance with their other duties. So that's my attempt to visualize the legislation as a whole. We're now going to jump into the sort of the deeper dives, and we're going to start with Mark on risk assessments. Mark.
Thanks, Adam. It may just be worth reiterating one of the key fundamentals of this new piece of legislation, which is that it's all about systems. It's not really about individual things which have gone wrong or particular pieces of content. It's about platforms having systems in place to guard against harms and illegal content. And the system really has 2 main facets to it, I think. One is that you assess what the risks are, and that's what we're going to talk about briefly now, and then you mitigate them. And if you fail to do that, then Ofcom will take steps against you, and we'll come on to those later in the talk. There are, I think, 2 areas of great employment creation which will result from this bill, and one is in risk assessment. In the same way compliance people have become everywhere in financial services companies, so risk assessors are going to become even more important parts of all sorts of online service companies. The risk assessment, or various times then match the various duties set out elsewhere in the legislation. So, for example, when we're talking about illegal content, there is an illegal content risk assessment duty. The starting point for how you go about the risk assessment is Ofcom, and Ofcom is the starting point and will be heavily involved throughout this whole process. They will have a duty to create risk profiles for different types of services. And when they do that, they're going to look at the way those types of services typically operate, their facets, and really what the potential harms that may arise from use of those services are and who their user base is likely to be. Then based upon those risk profiles, each service which is in scope then has to do an assessment of its various risks against that risk profile. And I've put there how a risk assessment is defined in the legislation, slightly repetitive assessment to identify, assess and understand such as the following as appear to be appropriate, taking into account the risk profile that relates to services of that kind. And that includes aspects such as the user base, the level of risk of users encountering relevant content, the nature and severity of the possible harm, how the service is used, its functionality and whether that increases the risk, and how the service can reduce the risk. And there is a specific duty to consider whether the service is accessible by children. And as Adam has said, then that leads to various other duties as well. So it's going to depend upon services understanding very well how their own services operate, who can access them and what is available on those services, and then looking at what can be done as we go on to mitigate those risks. On the next slide, put up some of the content which has already, I suppose, come up in a different form, which is, well, what are the different types of risk assessments as they apply to the different types of services? So all services are going to have to carry out and maintain illegal content risk assessments. All Category 1 services are going to have to do adult risk assessments against concerning harmful content, and children's risk assessments against harmful content are going to have to be done by all services likely to be accessed by children. So quite sweeping. Not all services will have to do all forms of risk assessments. Category 1 services are going to have to do the most, as with everything, but everyone is going to have to do some forms of risk assessment against the profile which will be put out by Ofcom. When do you have to do these risk assessments? The draft legislation is a little bit vague. There is a general duty to keep risk assessments up to date, which implies that there should be a continual risk assessment operation going on. We may get more specificity on that as the bill moves through the legislative stages. But there are also specific dates against which risk assessments should take place. So when Ofcom first publishes its risk assessments or its risk profiles at the beginning, within 3 months of that, so once the legislation's in, you'll have 3 months after those to carry out your risk assessments. Every now and again, Ofcom may make a significant change to the risk profiles for particular types of services, and if they do, then the services will then themselves have to match that by updating their own risk assessments. If there is a new service which is launched which is going to be in scope, then that has to be the subject of risk assessment. Similarly, if there's a change to the design or operation of the service, which, for example, brings a service into scope as a regulated service, or does something which is likely to change the risk profile of that particular service, then it has to be updated in terms of risk assessment. And then when the situation changes, that language which suggests a kind of general duty to look at how things evolve crops up in various places. So, for example, about children, there's language about if there's evidence that the reduced effectiveness of any systems or processes are in place to guard against harms, or response to evidence about a significant increase in the number of children using the service. So it's very much a dynamic duty. And as we'll come on to talk about a bit later, Ofcom has enforcement powers for failure to carry out risk assessments, and that would include carrying out risk assessments, but not carrying them out to a good enough standard. That's all I was going to say about risk assessments, but that I think then leads in neatly to Sue Yang on safety duties and content.
Thanks, Mark. So I'll be talking about what actually constitutes illegal and harmful content and the safety duties that services need to meet in relation to that content. As you've already heard, there are 3 types of content at play: illegal content, content that's legal but harmful to children, and content that's legal but harmful to adults. And within these, the legislation also sets out what I'm going to refer to as different severities of content, and the safety duties that attach depend on the type and the severity of content that we're dealing with. As has been mentioned already, the safety duties are closely tied to the outcome of the risk assessments. So, for example, there are measures, there are obligations to take proportionate measures to mitigate risks as identified in the risk assessments. And when proportionality is assessed, that's also done taking into account the results of the risk assessment. I also just wanted to flag at this point that there will be codes of practice setting out recommended steps for services to take to comply with safety duties, many of which, as you'll see, are rather broad. So what are the types of content that we're looking at here? Taking illegal content first, this is defined by reference to what constitutes a relevant offence. And there are several different severities. So at the top, we have terrorism content and content relating to child sexual exploitation and abuse, or CSEA content in the legislation. And these relate to specific offences set out in Schedules 2 and 3 of the draft. There's then priority illegal content that'll be defined in regulations by the Secretary of State. We don't have these yet, but the government response to the online harms white paper consultation suggests that these priority categories might include things like hate speech or sale of illegal drugs and weapons. Finally, there's content relating to any other offence, the intended victim of which is an individual or individuals. And what's really interesting about all of this is that the definition of illegal content doesn't actually rest on whether something is or isn't, in fact, a relevant offence. Instead, something will be illegal content if the service provider has reasonable grounds to believe that the content or its dissemination constitutes a relevant offence. So that's potentially much broader, and it means that in all the grey areas where it's not quite clear if something constitutes a relevant offence or not, the legislation errs on the side of being over-inclusive. Then we have content that's legal but harmful to children. Again, there are priority categories of content, primary priority and ordinary priority, which will be designated in regulations. The government consultation response suggests that this might include things like pornographic content or violent content. There's also a category of non-designated harmful content. And this consists of content that the service provider has reasonable grounds to believe would give rise to a material risk of significant adverse physical or psychological impact on a child of ordinary sensibilities at any age. And when assessing what it means to have ordinary sensibilities, the legislation also says that if particular content would particularly affect people with certain characteristics or who are members of certain groups, then the person of ordinary sensibilities should be considered to have those characteristics and be a member of those groups. Finally, content that's harmful to adults. Again, priority content will be designated in regulations, but the consultation response suggests that it could be things like abuse that doesn't amount to an offence and content about self-harm, eating disorders and suicide. As for children, there's also a category of other harmful content, which is content that the service provider has reasonable grounds to believe would give rise to a material risk of significant adverse physical or psychological impact on an adult of ordinary sensibilities. There are a few exclusions, which you can see set out in the slides. The ones I'll just flag are that IP infringements are out of scope, as is content that is harmful due to its potential financial impact. So what safety duties apply to these different categories of content? As Louise mentioned, I'm going to go through the duties for user-to-user services. The duties for search engines are not identical, but they are very similar. For illegal content, all services have a general duty to take proportionate steps to mitigate and effectively manage the risk of harm to individuals as identified in the risk assessment. There are also specific content minimization duties. Slightly curiously, the legislation doesn't specifically address what's required in this regard for terrorism and CSEA content. That might be because this will be set out in the codes of practice. And in fact, we already have interim voluntary codes of practice that do contain duties to identify, review, and remove these kinds of content. For priority illegal content, there are duties to use proportionate systems and processes which are designed to minimize the presence of this sort of content, the length of time it's present, and its dissemination on the service. And for all types of illegal content, services need to use proportionate systems and processes designed to swiftly take down illegal content when notified of it or when the service otherwise becomes aware of it. So as Mark mentioned, this is very much tied to systems and processes. There's no sort of prescribed measures that have to be taken. According to the government consultation response, some options of systems and processes could include the obvious things like user tools, content moderation, and recommendation procedures. For content that's harmful to children, Remember, these duties are only for services likely to be accessed by children and limited to the parts of the service that it's possible for children to access. Again, we have a general duty to take proportionate steps to mitigate and effectively manage risks and mitigate the impact of harm as identified in the risk assessment. The content minimization duties require proportionate systems and processes designed to prevent children from encountering harmful content. For primary priority content, this extends to children of any age, and for priority and non-designated content, this will be if the content has been assessed in a risk assessment to particularly affect children of a certain age group, then the systems and processes should prevent children of that age group from encountering the content. For content that's harmful to adults, we don't have the general duty, nor do we have specific content minimization duties. But services do need to have and apply terms and conditions that specify how priority content and other kinds of harmful content that have been identified in a risk assessment will be dealt with on the service. And this reflects a general principle behind the legislation that adults should be empowered to keep themselves safe online, rather than sort of blanket prevented from seeing things. With respect to terms and conditions generally, there's now actually an awful lot that needs to go into these. For illegal content and for content that's harmful to children, terms and conditions will need to specify how individuals will be protected, and they'll need to address not only these broad types of content, but also each severity of content that the legislation deals with. For content that's harmful for children, they also need to address each particular kind of primary priority or priority content separately. So taking the examples from the consultation response, that would mean that violent content, pornography, self-harm content, all of these would need to be individually addressed in the T's and C's, which will be a really big exercise. And finally, as Adam mentioned, there are duties across the board to allow easy reporting of content and operate an accessible complaints procedure. So how are services supposed to comply with all of this? As you've seen, the legislation imposes active duties to take steps, use systems, actively do things. But at the same time, the general duties and the content minimization duties are vague and broadly drafted. The answer may lie in the codes of practice. Under the legislation, Ofcom must prepare codes of practice describing recommended steps for compliance with duties. Services will be treated as complying if they take the steps described in the Code of Conduct, and provided that terrorism and CSEA content aren't prevalent on the service. The codes of practice won't be the only option for compliance, reflecting the fact that this is intended to be a risk and principles, systems-based regulation. But in reality, it might be, depending on their contents, that following the codes of practice may be the easiest way to comply. We do have a couple of examples in the form of the voluntary interim codes of practice for terrorism and CSEA content. In the interest of time, I won't go through those, but there's a link on the slide, and they're fairly user-friendly. The final codes of conduct may not entirely follow a similar approach, given that these codes are voluntary and they do deal with the most serious categories of content. So where there are some slightly aspirational elements to them, like industry-wide cooperation, things like that, those may well not follow through to the codes of practice that are about compliance with this legislation. The drafting of the codes of practice will be quite an involved process. Ofcom will need to consult representatives of regulated service providers, users, experts, and interest groups, and there are a lot of principles they'll need to have regard to. So importantly, there will be opportunities for affected stakeholders to be heard, potentially through industry or interest groups, and we would encourage you to get involved, as the codes of practice will likely be a really important part of all of this. And with that, I will hand over to Tim on freedom of expression and privacy.
Thank you very much, Sue Yang. So yeah, over the next 4 slides, I'm going to be discussing free speech and privacy and what protections there are for that. One of the weaknesses with the online harms white paper was the lack of detail on the protection of freedom of expression. So let's see how that has been addressed in the online safety bill. So there are 2 types of duties, those that apply to all user-to-user services and search services, and then the other is for category 1. So for all services, there is a duty when deciding on implementing safety policies and procedures to have regard to the importance of protecting users' right to freedom of expression within the law and users from unwarranted infringements of privacy. You'll note there that it has to be freedom of expression within the law, which means English law, and I'll come back to that. And it doesn't say that relating to privacy, but it must mean privacy law. And then for the sort of the bigger category 1 services, there are additional duties such as to carry out and publish impact assessments on the protection of freedom of expression and privacy. So that's an additional impact assessment to the ones that Mark mentioned for category 1 services. And also the terms of service, or in a public statement, the service provider must state the positive steps that they have taken in response to the impact assessment to protect freedom of expression and privacy. So let's have a look at what freedom of expression means, because the online safety bill gives no clue as to what freedom of expression is. And there is actually quite a lot of law under English law and the law provided through Article 10 of the European Convention on Human Rights, which also comes into English law. And I'll just give you a couple of examples. First of all, the case law of the European Court of Human Rights has said that Article 10, the right of freedom of expression, is applicable, subject to exceptions, not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock, or disturb. So you can see that free speech includes, offensive and shocking and disturbing information. And in the English case in the Court of Appeal, Redmond and Bate against the DPP, 1999, which is a hate speech case, Lord Justice Sedley said free speech includes not only the inoffensive, but the irritating, the contentious, the eccentric, the heretical, the unwelcome, and the provocative, provided it does not tend to provoke violence. And freedom only to speak inoffensively is not worth having. So you can see from this that if you're going to be able to apply and have regard to freedom of expression, it's important to have regard to what the law actually is. And the online safety bill itself doesn't explain that. So you need a bit of case law in addition. And for category 1 services, as I say, there's additional requirements. And as for privacy, what does privacy, what's the role of privacy here? Well, it's probably that users have a right to have themselves and their content not really being spied on or interfered with by service providers. And of course, some people, when they post stuff on social media, have their settings public, in which case they probably won't have much, if any, privacy protection. But of course, others may be communicating just with one other person in a private communication, or to a small group of friends or family. And of course, Article 8 of the European Convention, the right to private life, family life, home and correspondence including communications, and the Data Protection Act 2018 and the GDPR are likely to be engaged. So service providers will need to understand what the rights of freedom of expression are under English law and what the rights of privacy are under the tort of misuse of private information and data protection law. So the next 2 slides, or the next 3 slides, relate just to category 1 services. Those are the bigger players which get more obligations. They have a particular duty in relation to content of democratic importance. So what is that? Well, first of all, it has to be news publisher content or regulated content. News publisher content is content more or less by professional news organizations, and regulated content is content that Louise has described the scope of earlier. It's content that basically falls within the online safety bill. And this is the key point, the content is or appears to be specifically intended to contribute to democratic political debate in the UK or a part of the UK. Basically this protects political speech, and Category 1 service providers have to give more protection to political speech. What are the duties? There are three. First of all, to ensure that the importance of the free expression of content of democratic importance is taken into account when making decisions about content and users. Secondly, to ensure that the systems apply in the same way to a diversity of political opinion. In other words, treating different political opinions consistently and equally, and specifying in the terms of service the policies and processes which take into account content of democratic importance. I'm not entirely clear why political speech is only given this protection for Category 1 services, because political speech is protected under European Convention on Human Rights Law is the highest category of speech protection. There is under Article 10, but maybe the bigger you are, the reasoning is the more protective you have to be of this political speech, which is highly protected anyway, and the more neutral you need to be. So is content contributing to a democratic political debate in the UK? Does that mean just UK issues or issues that are of concern in the UK? And I think it's the latter, but we'll have to wait and see. And how do you apply systems equally across a diversity of political opinion? So that's pretty difficult. Are you going to treat a debate in favour of a xenophobic, nationalistic political party exactly in the same way as a mainstream centrist party? And these are going to be difficult questions for service providers. So the next type of content which Category 1 service providers have to give extra protection to is journalistic content. I will just explain what that is, and then I'll explain the duties, and then that's the free speech section completed. So journalistic content is content which is, again, news publisher content or regulated content. And then this is the key thing, it's generated for the purposes of journalism, and it's UK linked, which means UK users are targeted, or it's likely to be of interest to a significant number of UK users. So I'm just going to get to the next slide, which is the duties. So the duty is to ensure the importance of the free expression of journalistic content is taken into account when making decisions about content and users. And if you're going to make a decision as to whether to take down content or to suspend a user, you have to have a dedicated and expedited complaint system available to a person who considers the content to be journalistic and who is the user who uploaded it or created it. You have to also make sure that if you reverse your decision because you then decide it is journalistic content and it is protected, that you can swiftly reinstate the decision. Finally, you have to specify in the terms of service how journalistic content is identified and taken into account in the policies for handling complaints. So as you can see, free speech, privacy, and journalistic content and content of a democratic importance comes into play in the implementing of safety policies, in the safety duties, in the complaints procedures, in the codes of practice, and in an impact assessment and in your website terms. So it permeates the obligations in the Act. And I'm now going to hand over to Mark to discuss Ofcom.
Mark there. I'll pick up quickly on Ofcom until Mark, you can return. Shout loudly if you're there, and I can hand back over to you. Just a couple of words on, as we finish up, what Ofcom's role in all of this is as the regulator. I've already mentioned their sort of obligation to draw up and maintain registers and put people into different categories. They themselves will have to carry out kind of risk profile assessments for different types of service. And that will then sort of kick off the service's own risk assessment processes. They've got to prepare codes of practice, and they're going to be really important codes of practices because to a great extent, if the services comply with the codes of practice, that will be kind of treated as compliance with the duties themselves. And they've got a lot of kind of information and guidance obligations, for example, about how technology should be used by providers to meet their duties. And ultimately, they are the enforcer. And there's a wide range of compliance and enforcement powers they've got. Child sexual exploitation and abuse and terrorism content being always at the sort of top level, as Zuyang was outlining. So for those, that content, an obligation, a power for Ofcom to require services to implement certain technology. And then there's a process that Ofcom will go through if they've identified whether a service hasn't complied with their requirements via provisional notice of enforcement. And then ultimately, if there's a problem, they can impose access or service restrictions on the service. So a service restriction might be a kind of a third-party service provider to the service, payments processing or ad serving, for example, restrict use of those services, or indeed, it's most extreme, an obligation, a power for Ofcom to block access to the service. They've got quite powerful information investigation powers, rights of entry, very significant. I've mentioned the fines earlier, 10%, very significant figure. In GDPR, it's 4%. In the DSA, 6%. But the UK government has gone for a world-beating 10%. Super complaint organisations will be able to complain about service compliance. And as a backstop, if this doesn't have enough effect, there is a potential for criminal sanctions to be a senior manager of these services. So just looking briefly to the future, as we've all been alluding to, there's a lot more to come. The secondary legislation around categories and thresholds, for example, codes of practice about how services can comply with duties. And therefore, there's a lot of opportunities now for services to attempt to influence policy. The pre-legislative scrutiny is happening at the moment. Then the secondary legislation, the codes of practice, will be produced. And there's also the impact assessment that the government has published for services to engage on as well. So this is as I say, the sort of the overall view of the legislation. Hopefully that's a sort of a useful checklist, aid memoir, attempt to organise everything for you, so you can sort of tick off what it is that you've been doing to comply. And just before we go, we're going to leave you all with a question, which is, do you think the Online Safety Bill strikes the right balance between managing illegal content, harmful but lawful content, children, but at the same time protecting freedom of expression? Yes, yes or no. I'll give a minute or so to respond. while everyone responds, we just had a question in the Q&A asking about whether the law's live yet. It's not yet live. In terms of timing, I suppose it depends on how quickly the legislative processes can carry on. Maybe this year's ambitious, but maybe we're looking at 2022 for this to come into force. A couple of voluntary codes of practice were published at the back end of last year, at the same time as the final government response was published around terrorism and CSEA content, but they are voluntary. Oh wow! Well, 55 to 45 in favour of it striking the right balance. So there's a lot more in favour of yes than we were anticipating. I think we've just had a question in just to finish off. What would be our practical advice to platforms now? I think I think it's probably to go back to that building block. What is the building block of this legislation? It's risk assessments. It is to once services are identified if they're in scope, and the extent of those services that are in scope and the extent of the content. I think the first thing would be to start thinking about the risk assessment, because from that the processes flow. What steps have to be taken to mitigate harm? What the terms of use have to be amended to say, how the internal procedures for dealing with reports of unlawful content, and how freedom of expression and related concepts need to what regard has to be had to those freedom of expression concepts, all will be based on the risk assessment. So I think starting to identify risk will be the main thing to start on now. With that, we will say farewell, as we've just hit 5 o'clock. Here we are. Here's our contact details. Please feel free to reach out about anything you've heard here. I think it's fair to say that there is a lot more to come on this. This was a first look. We'll take on board your feedback, and please do fill in the questionnaire as we end as to what it is you might like to hear from us more on. And then we will look forward to speaking to you soon, and who knows, maybe even getting together in person before long and discussing all these things in real life. All the best, everyone, and farewell. Goodbye.